I'm an innovation manager at Ventures. My name's Andrea Deering. I'm responsible for assessment of innovations slash inventions slash intellectual property from University of Maryland College Park. We also work to move these kinds of new inventions that come out of research to the marketplace, meaning to the public, where they can be products or services that have beneficial impact. So other duties in the office are determination of marketability, including preparation of marketing information and determination of appropriate intellectual property protection required, negotiation of terms and preparation of draft license agreements with companies. And I am one of 8 innovation managers in the office. I have a science background and intellectual property and business experience, and all of us innovation managers have different combinations of that kind of experience and education and university and industry work experience. We each have a different portfolio of inventions and people that we work with at the university. So I'm going to talk about Ventures and start with innovation at University of Maryland. University of Maryland College Park is 40,000 students, 700 million in research expenditures last year. And in that year, we had about 175 invention disclosures, 280 patent applications, and 64 patents issued. In 2025, combined with University of Maryland, Baltimore, we were ranked 10th for patents issued among U.S. public universities, which is pretty good because we're competing against big conglomerate university systems like University of California and University of Texas. So our role in the office is to basically support the researchers who are the lifeblood of the university. We have lots of roles, including supporting innovation for both faculty and students, protecting intellectual property that's owned by University of Maryland, Baltimore, starting companies, securing investment, creating jobs. We provide learning opportunities for students. We generate revenue from commercial license agreements. We are available to attend department seminars and lab meetings to meet with faculty, postdocs, and students, talk about what we do. And it all adds up to drive University of Maryland impact. So our job and our role begin with the UMD IP policy. In general, UMD owns intellectual property, for example, patentable inventions or protectable software, with the exception of scholarly works by professors. Researchers have an obligation to disclose new intellectual property under the UMD policy as employees and as a condition of almost every research award that you get. And one of our office's big jobs is to keep up with reporting of new inventions for research grants in order to remain in compliance with those grants. Down the road, after inventions are disclosed and intellectual property is protected, we do our marketing, we license to companies, products are developed and sold. Our office receives license income, and under the UMD IP policy, the income received is distributed 50% to the creators / inventors, that means the faculty or students, as personal income, 25% back to their departments to foster additional research, and 25% to Ventures for additional technology development. The role of our office and tech transfer at University of Maryland College Park has a long history, starting in 1975. Over the years, we've counted 4,000 inventions, over 1,000 patents, 747 license agreements, and licensing revenue of about $47 million. One of our major outputs at University of Maryland is startup companies. We are particularly active as universities go. Over the years, we've started 140 companies, with University of Maryland intellectual property. 58 are still active, 592 jobs created. I think those are Maryland jobs. $858 million in equity investments in those companies, annual revenue $61 million, and senior management 39% minority, 19% female. So I am going to move on to working with Ventures and how this is useful to everyone else at the university. What is intellectual property and our procedures, which should be 1, 2, 3, invention disclosure, marketing, and licensing. How do I know when I have an invention? It varies, obviously, in different cases. Most inventions result from research, solving a problem, and inventors often describe moments that led them to see a problem differently. So the invention has to be a novel solution that's not already out there. And then it should be possible to sell the invention somehow as a product or a service. There's not much point in disclosing an invention and investing in protecting it if it doesn't need that kind of translation to get to the public via commercialization. So a lot of research goes into the public domain and benefits the public directly. But in some cases, it's not going to make it to the public unless we somehow collaborate with a company, generally, to translate it into a product or service that will have value. The moral of this talk is contact Ventures if you aren't sure. We will start at the beginning and answer any questions that you have. Types of intellectual property include a patent, copyrights, and tangible material. These are types of intellectual property that we can license to companies under a contract. Patenting is not an end in its own, just to get patents. We need to determine if patent protection would be essential to development of the invention for public use. Copyright exists for software and all kinds of written instruments, databases, things like that. And we do a lot of licensing of non-patented materials. And tangible material can be material itself is going to be transferred to a company for development without any kind of additional IP protection. Again, if you think you have intellectual property and have questions, contact us. I'm going to start by talking a little bit about patenting, but that's not all we do. Patent criteria in order to get a patent granted by the United States. There's 3 elements: novelty, utility, and non-obviousness. Novelty is pretty straightforward. If someone has already invented this and described it and it's in the public domain, we can't patent it and say that we own it. It has to be useful, can't be decorative or something like that. And non-obviousness is the trickiest aspect of patenting, and it is the kind of rejection we get from the US Patent and Trademark Office most often in patent prosecution, and we have to be able to argue. So at least initially in our patentability assessment, we look to see if the invention is already described somewhere, but then we spend a fair amount of time looking at similar inventions and trying to determine if we would get obviousness rejections from the USPTO and how to argue them. So that's a big part of initial assessment and, if we move ahead, of the patent prosecution. When to patent is a major consideration. You don't want to do it too early or too late in the process of discovery and development. It's very helpful if the idea is actually reduced to practice, or the inventor can describe the concept in sufficient detail so that the patent itself will be a template so anyone can duplicate the invention. So there should be constructive reduction, and the more data proving the value of the patent and its novel properties, the more valuable the patent's going to be. That said, you can't do it too late because it has to be within 1 year of public disclosure. In the US, you get a 1-year grace period after any public disclosure in which to file a patent application. If you file later than that, you're not going to get the patent granted. Public disclosure includes scientific publications and oral presentations to the public. So this is, again, something to discuss with Ventures if you aren't sure. In countries other than the US, most of them, there isn't a 1-year grace period, and you have to file before public disclosure in order to get a patent in that country. We would never suggest delaying a publication, but the assessment and the patent application preparation do take time. So we need to have a conversation and some balance when we're deciding how and when to file a patent application. For anyone who doesn't know, what does a patent look like? It has the elements of a scientific manuscript, and it has claims which define the legal elements of the invention and determine the scope of protection under patent law and whether infringement has occurred. So the duty of a patent attorney, and we work with outside counsel from this office, is to express an invention in legally valuable claims, which describe each element of the invention that can be protected by a patent. An example patent claim for an invention for gait analysis. This is an insole that goes in a shoe and analyzes various aspects of a person's walk. This is what a claim would look like. There's going to be a whole description. There's going to be lots of data and background and explanations of the value of the invention. But then the legal invention itself will come down to the claims. So this lists elements. It says it's an apparatus. It's got these elements: 4 sensors, a processor, and a way of collecting data to determine a pose or abnormality. So in the patenting process and in the initial assessment process, Ventures will work with you, the inventors, to understand the invention and to prepare these claims based on what art is out there, what the competition is doing, and where we'll find the most value in a patent. The invention disclosure process. You can find the invention disclosure form at our website, send it to our email. We are upgrading, and soon it will be a fillable form on the Koali Research dashboard. In the initial process, each invention disclosure is assessed for both patentability and commercial potential. We start with an inventor meeting. We talk to you, get lots of background on your work, review publications, plans to publish, funding sources so that we can report the invention properly, and we discuss goals. Then within our office, each innovation manager does the intellectual property and commercial assessment. So this includes a patent search, an understanding of the market and potential licensees, and what would the return on investment be if we were to invest in patenting this. And we make a go, no-go decision on whether to proceed. Less than 50% of new disclosures that come into our office are patented. There's a lot of reasons for this. There's software that's copyright. We have a limited budget, so we do have to triage and make sure that we can afford all the money that we're going to invest in patenting. And in some cases, an invention doesn't need a patent. A patent is not a valuable tool for development and moving the invention into the public domain. So we get inventions, our office gets inventions translated to the public domain, not just through patents, sometimes even without intellectual property protection, not just commercially. Sometimes we work with non-commercial entities. So throughout this process, we talk to you, we understand the best ways to move ahead with intellectual property. The elements of the invention disclosure include a description. The more data, the better. We want your understanding of the commercial potential and of competition, potential manufacturers. These are potential companies to license and develop the technology. And we're always ready to talk about startup companies if that seems to be appropriate. I'm going to cover some myth busters. These statements are all true. Ventures will not stop you from publishing your paper. We would never get in the way of publication. Ventures will not license your innovation to a company without your knowledge. You will be able to continue research when your innovation is licensed and at every stage. We never get in the way of continuing research. It's important to understand that submitting the invention disclosure to our office does not mean that you have a patent application or a patent. So there's no protection until we determine if that protection is appropriate and file a patent application. And in general, an idea, no matter how great, cannot in itself be patented. We see lots of great ideas. It's not always appropriate or possible to patent them. So a lot of our job is figuring out the best way to proceed with research translation. Once the invention disclosure comes in, usually our first due diligence step is to see if it's patentable, identifying the elements of the invention, assessing the patent landscape for novelty issues to see if someone's already described it. Throughout, we talk to you, we encourage inventor input. And the final goal is to identify claims that will be written into the patent application that will be as broad as possible and that will be valuable. We also do a marketability analysis before deciding how to move ahead with a new invention. We need to understand if there's a commercial interest in licensing this kind of invention. We can reach out to companies to get market intelligence, and that's the most useful data we can have in terms of future licensing. And of course, if a startup is suitable, can it access the resources needed for success? A startup company needs dedicated management and funding, and our office's startup support team is, of course, here to put the startup in touch with the necessary resources at every stage. Ultimately, our office and the university were looking for a return on investment via commercialization, which means that there will be public benefit. And if we're spending a lot of money on patenting, that money will be reimbursed. And if a company is making a profit off University of Maryland IP, a portion of that profit will return as license revenues to the university. I want to take a little detour into software protection. I'm focused on patents a lot here because it's complicated and expensive. Software protection is a little bit less demanding and requires a little bit less assessment to decide to move ahead. Software can be protected by both patents and copyright. The copyright exists on the software. One major question that we have is, who are the authors? They'll be the creators, the people who actually wrote the software for copyright. If we file a patent on the algorithm, the method that underlies the software, that'll be the idea people. Big question, is it original work? Is that totally straightforward? Is there third-party / open source software that was modified as part of it? And a question that we've been grappling with and don't necessarily have the answer to yet, if AI was used to write the software, who actually created it? Again, these are questions that we will sit down and address when you disclose software. So finally, in this invention disclosure process, there's a decision on whether to pursue IP protection and license. Will the time and money investment yield a return? It's important to understand that a patent costs at least $20,000, and years of Ventures effort, might take 5 years to get a patent. Will there be a positive impact via commercialization? To be clear to inventors, having a patent granted does not mean commercial success. As Elon Musk has said, patents are for the weak. A patent isn't a good crutch to carry scientific advances that don't happen to have commercial value. So we want to make strategic decisions, and with strategic management, there's enormous value to university IP. So our next steps in terms of strategy, once we've decided to move ahead, is to pursue marketing of the technology, identifying licensees, and getting it licensed. The bottom line is, will a company license and develop this technology, creating value to the customer community? What we can do in this office is reach out for market feedback and understand what potential licensees think of the invention. For example, sometimes we'll hear, we don't want this technology. And then the question is, why? Why doesn't it fit into your pipeline? Why do you think it wouldn't be competitive? And are there additional elements that would make it interesting to you? So in general, we're always looking for market feedback on our technologies as we try to license them. Our process is to identify potential licensee companies, prepare marketing materials, and reach out to company contacts. We ask, is this commercially valuable? We at Ventures gather the market intelligence, but in reality, most licensee companies come in through inventor contacts. And that will be inventors who are working with a company or who know people at companies. But more often, it'll be companies reaching out to the inventor because they're interested in the work, because they've seen a patent, they've seen a scientific publication, and that's how they come through to our office. So this is how we get to licensing. Oh, I'm going to talk for a second about other kinds of agreements. Outreach to companies might require confidential disclosure agreements, which protect non-public information from the university shared with the company. They promise not to share it with anyone else or commercialize it. Or material transfer agreements, where we're actually sending some kind of sample of an invention or some kind of device to a prospective licensee. And again, it's protecting it so that they cannot take it and commercialize it. And our office handles both confidential disclosure agreements and material transfer agreements internally. Office of Research Administration also does. They will handle incoming material transfer agreements. So contact us if you have questions. Moving on to licensing. This is our final goal for research translation, a successful license to a company. A license is a contract between University of Maryland and a company, allowing the company to develop and sell University of Maryland intellectual property, usually exclusively. That's why there's value to the licensee. In return, the company shares its profits with UMD in the form of royalties on sales and other kinds of payments. The license contract and the negotiations with the company start with a term sheet. The term sheet says that the university grants permission to use the intellectual property and has certain requirements for the company, including meeting development milestones. So if the company does not develop the technology, puts it on the shelf, we can terminate the license. It's nice, besides royalty on sales, to get some kind of upfront investment, a license fee, reimbursement of patent expenses, in order that if it takes years for the company to commercialize the technology, University of Maryland is seeing some kind of return on the work, and the company is also motivated to keep working if they have to pay for it. We get a royalty on sales, and in some cases, we'll get equity, and if a company doesn't want to be paying cash. So we have equity positions in almost all of our startup companies, for example. And then, again, when revenue comes in, it is shared under the IP policy, 50% to inventors, 25% to departments, and 25% back to Ventures. So which companies license UMD inventions? Here's a snapshot of our output. Examples of licenses to existing companies. We license to all different kinds of companies, huge companies like Oracle, little companies like AbbVac, which is a 4-employee company in Rockville developing vaccines. 1/3 of our licenses are to startup companies created by Ventures. And of all of our licenses, 20% are software with no patent, 33% are devices, 40% are biomedical. Examples of devices are efficient batteries, HVAC energy saving solutions. We've got citrus greening treatment, and we've got superwood, wheat, and apples from the agriculture school. And a success story that I always like to talk about is IonQ, which was the first publicly traded company in the world in the quantum computing space. This is a quantum computer company, startup out of University of Maryland, from Chris Monroe and his colleagues in CMNS. And I just want to review the timeline of Ventures' involvement in the company, it was we got a first invention disclosure in 2012 and filed a provisional patent application in 2013. The first patent was granted in 2018. And with the support of a company and a company budget, we now have 271 patents and applications in that portfolio. The exclusive license agreement was signed in 2016, and the company went public in 2021 with a $2 billion valuation, coming from a $2 million initial investment 6 years earlier. So this is a great success story that CMNS are justifiably proud of. So to wrap up, why work with Ventures? The commercialization of technology is an extension of academic research, and our goal is to translate the research from data with ideas into products which impact the public. Can't all be done in the university, so Ventures will bridge the gap between scholarly innovation and real-life application. We are here to answer any questions anytime, or to come and speak to anyone who would like to hear from us. Thank you very much.
Thank you, Andrea. That was great. Unmute myself. There's some construction noise here in the office, so I apologize if you hear that. So we have a question about INQ. How did they get VC money, and did that money come to UMD?
They got VC money by pitching their technology to VCs and having a great technology. I wasn't there, but from what I've heard, a lot of work by the inventors, a lot of contacts from the inventors. And did that money come to the university? The university had equity in the company, which has now been sold. So yes. And you might want to add to that, Ollie. You have more knowledge of INQ.
Yeah, so it's also important to note that INQ, and especially back then, so they were entering a very, very early nascent quantum computing industry, that the industry itself is a big science project. So having two scientists, run the company made sense because it's just one big science experiment still many years later. So this is typically an exception to the rule. And so the pitch deck probably looked a lot more sciencey than it usually does. We actually do have entrepreneurs in residence who can help you with the pitch deck development, and if you need such help. And maybe you can reach out to Chris Monroe and see if he can share the pitch deck. So venture capitalists, how do you find? So the question is, how do you find VCs? It's through the University of Maryland, we have several opportunities. So one, we have Startup Showcase. It's now going to be an annual event where we bring startups and we invite investors to come and talk to our startups. The next one will be in November. No, I'm sorry. Yes, in November of this year. Last year was in October. We also have several investment funds that are run by professional investors, and we can make introductions as well when the startup company is ready. It's important to know that VCs do not fund technologies. They fund businesses. So if you have a technology, but you haven't necessarily found detailed specifics about who is your customer, who's your target market, because not everybody is going to want and love your technology. It's important to find what your beachhead market is first, and then get some very early traction, probably with some grant funding and such. And then VCs will be a lot more interested. Next question is, can you commercialize a website and a chat bot? Beth, would you like to take that?
Sure. I think yes, of course you can. Technically, Amazon is a website and they didn't even need a chatbot, so clearly that's possible. If you have a tool like a a web-based tool or something that you're building, and it will have a chatbot element as part of how people navigate the user interface. You're welcome to bring what you're building to UM Ventures and probably talk to me about it, and we can think about strategy and what your goals are with what you're creating.
Yeah, absolutely. The next question is, are you involved with I-Core? Absolutely, yes. We work very closely with MTech and the team that runs I-Core. And when we are working with teams on building a startup company, our first order of business is to evaluate IP. This is what Andrea was talking about, and Beth will do that as well. And then the next step would be for the PIs to go through I-Core. That's where the rubber meets the road, where you will be able to find out, does anybody need your innovation and in what form? What features does it need to have? What metrics does it need to achieve to be useful? And where could it be implemented? So it is a fantastic program that we recommend everybody that as the first step on the path to commercialization. The question is, oh, I'm glad to hear that you're now in the cohort. That is great news. You need help with stakeholder interviews. So you can reach out to us and let us know who you're trying to interview and see if we can make some introductions and help you there. Can faculty stay on faculty and run the business at the same time? It depends. So if originally at the very beginning, you probably can. As soon as the company gets funding, then the COI committee at the university will ask you to step down. And also, speaking of VCs, VCs are not going to invest in a company where the CEO is part-time. So you can still stay involved with the company as a consultant. You can absolutely, if you're a founder or co-founder of the company, you always will be a co-founder of the company or a founder. But if somebody else will need to be the CEO to run it, because again, investors would not invest in a company where the CEO is part-time, where you have a full-time role at the university and then running the company part-time. That's just not of interest to VCs in particular. And in general, it really is helpful to have somebody who can focus on the business side of things, like paying the bills, HR, lining up, reviewing agreements. There's all sorts of unglamorous side of running a business that is usually best delegated to somebody who is more interested in doing that rather than actual research and development.
Plus, we don't want to lose our great faculty to startup companies. We want to keep them working here.
Yeah. So typically what happens, so Beth talked about, you talked about Inventwood, right? And so there are several researchers at the University of Maryland, Lian Bin who is now at Yale as of a year ago, and Dr. Srini Raghavan. And both of them figured out a great recipe for churning out fantastic startups, yet still keeping their labs at the university running. They usually invent something with a postdoc or PhD student, and then they run that student, become the original CEO, and then go back to inventing more stuff. And they are co-founders of all those companies. They have, their technology is licensed into those companies. They have different approaches into how involved they are with each company, but that's individual, but that's their recipe for how they each have about 5+ startups each at this point. What if I want to license IP from another group? You just go to that university and license it from them. Yeah, so each university has a equivalent of our office. It's usually called a variation of Office of Technology Transfer, Technology Commercialization, or our office is called UM Ventures. But basically, you would need to license IP from that office. And no, we cannot help you negotiate IP licenses with other universities.
That said, experience you get negotiating with this university would definitely translate to working with another, so we can help you there.
Right. And if there was like a governing grant agreement, if it was for research and not for a startup company, and like IP was necessary through a subaward or something like that, then our office might be involved in those negotiations, like an interinstitutional agreement. But as Allison, not for a startup company. That would be on your own.
Right, and typically, even when your company negotiates an agreement with the University of Maryland, the company will be, so you as the professor will be asked to have somebody else negotiate because the university negotiates on your behalf as a professor against you as somebody who's wearing the head of the company. It creates a conflict of interest. And so the conflict of interest committee and rules ask that you ask somebody else to do that. But yeah.
So we can talk about if you have a specific situation, ways to work that out. For smaller ventures, we have had situations where a faculty member can manage the company initially, and we work out ways to bring in other people to be part of the company without, having to run it and to negotiate with the university. So we can certainly talk about that kind of problem specifically.
Yeah, there's a question that I am not sure. It probably was related to something we were talking about at the time. Is this an all or nothing situation or consulting options available? Are you referring to working at the company? If that's, yes, you can consult for the company. So it's not
And
all or nothing.
if you're bringing in someone to run a startup company, that's what I was just trying to express. It does not have to be an all or nothing situation where someone takes over the company and is completely responsible for it. Initially, it is possible to bring in people on a consulting level.
And then the next question, I'm also trying to understand that it's such an amazing portfolio. Do you have a direct reference list for ongoing clients or previous clients for us to reach out to personally to get a first-hand idea of the experience? You're talking about startup companies. We do have a list of startup companies. They live in our trade space, right?
It's,
Yeah,
especially those who failed.
They may or
not
may
be
not
on the
want to
list.
talk, right? That's up to
So
them.
companies failed because they were selling stuff nobody wanted to pay for, or not enough people were willing to pay for, or not enough people willing to pay enough for. So understanding product market fit is really important. And so going through I-Core is that very first step in doing that. We have other success examples. So the question here is about I guess, INQ as a success example. That is, you're right, it is not typical. So typically what happens is we have companies going through, we'll go through I-Core to better understand product market fit. That information helps them apply for, and that's even before you're a company, teams. The researcher can apply for MII Phase 1 grant to further validate technology, and not just R&D because of the science, but to do further R&D because that's what the market wants, and to make sure that the technology can do what the market wants, and develop commercialization plan And after that, typically the company is formed, technology is licensed, the company can apply for next stage MII funding, full company formation. And then we also have some funds that might put money in, and we can help we can make connections to VCs. SBIRs were reauthorized yesterday, so yay, that's additional money for R&D if you need that. And there's lots of changes there, I'm sure. But yeah, so typically it's, the technology is licensed into the company. There's, the use of MII and SBIR funds early on, Discovery Fund, Momentum Fund, and then they fly. That's typical. There are other grants depending on the industry. So there's State of Maryland grants for clean energy, biotech, and such. But you're welcome. So I wanted to drop this here real quick. So there's a website if you're interested more about in startup creation process. We have a website called Startup Guide, and Startup Guide is step-by-step instructions on how to build a company using University of Maryland technology. University of Maryland technologies, how to work, what happens at what steps. So you'll see the first step is tell us about your innovation. So that's where Andrea and Beth are your very first points of contact on your way. And then you go through I-Core. We have entrepreneurs in residence. You will keep working with your innovation managers on IP management plan, doing market research for your innovation, trying to figure out what is it that it can do, and so on and so forth. We have a separate webinar for that. So I don't know, Andrea, Beth, do you have anything to add?
Good conversation. Thank you, everyone.
Thank you.
Yeah. Last call for questions, either written or you can raise your digital hand and I can unmute you. And if not, you can reach out to our office by email or phone or just stop by. Well, thank you so much to everybody who stopped by today. And thank you for the great questions. All right, thanks. Bye-bye. And thank you, Beth and Andrea. Bye.